It'll require some analytical work, trying to figure out what the consequences of different decision structures are. And some normative work as well, some evaluative work, trying to figure out which structures might be better for particular situations. Okay, so let's begin first by thinking through what a tiebreaker is. How can we identify a tie-breaking decision structure? What makes it different, special, compared to other possibilities? Well, we can represent a couple of options visibly. So on the upper left is a visual of a soccer penalty shootout. These shootouts happen when at the end of regulation time, the score is tied, and a tie seems intolerable. So then we take alternating penalties. On the your right side of the screen, that's an image of the United States Senate around 1850. It actually has a tiebreaker built into it, probably not for dramatic purposes, as in the soccer situation, but it does have a tiebreaker built in. That is, if and only if the votes are equally divided in the Senate on a vote that requires majority for passage, if and only if there's a tie in the votes, then the vice president breaks the tie. Now, there are a couple other instances I can raise here to try to distinguish these ideas of a tiebreaker narrowly defined from a looser definition of a tiebreaker. So the bottom left is a situation of, well, it's a first base situation, it's a baseball situation, trying to figure out whether the runner is out or safe. And on the bottom right quadrant is an image of the House of Representatives here with Nancy Pelosi presiding. It runs on a different rule than the Senate does. So in the House of Representatives, the rule is motions require a majority to pass, with some exceptions. They require a majority to pass. Now, when votes are equal, that will resolve the, quote, tie in favor of non-passage. But that's a different rule and a different decision structure compared to the Senate, where the Senate's rule is, if tied, bring in the vice president, if he so chooses to vote. That's a different kind of decision structure. They both break ties in equal vote situations, but they do so in different ways. Similarly, this baseball situation, now probably some of you have heard of the rule, the tie goes to the runner. Yes, you've heard of this rule? There is no such rule, at least not in Major League Baseball. People say that, but that's not actually the rule. So the rule in the official baseball rules is that it's this. It states the batter is out if he or first base is tagged before he touches first base. So it doesn't say, well, judge on speed. If tied, tie goes to the runner. And that's a somewhat subtle difference, but it turns out to be a meaningful difference. Tiebreakers in the strict sense are like the penalty shootout above and about like the vice president up above. Not like situations of so-called tie goes to the runner or majority vote requirements. Those are different. They're meaningfully different. So to define the idea narrowly, we want to knock out these lower two, loose definitions of tiebreaker and be more specific. So what's a tiebreaker? Well, narrowly defined, it involves lexically ordered decision rules for making the same decision. Now, lexical ordering, maybe you've heard of this and maybe you haven't, but the best example is alphabetizing. So when you're alphabetizing words, you look at the first letter of two words you're comparing, and if the first word starts with A and the second word starts with B or any other letter, then the first word wins. And it doesn't matter the rank ordering of any other letter. Those are totally irrelevant because that first letter comparison takes lexical priority. All right? So tiebreakers have that feature. There's a lexically superior decision rule and a lexically inferior decision rule, and you never are supposed to look at that lexically inferior rule unless the first rule breaks down. Moreover, these two rules are designed to make the same decision. There's a little bit of vagueness there. You have to be able to think that the two rules are attempting to achieve the same goal, the same decision. Okay, so now graphically we can illustrate some differences. On the left side is an ordinary decision situation with a unitary decision structure involving the same decision. On the upper right is a decision structure that I'm interested in. It has a lexical structure, and it's also about the same decision. So up here, you can think of the decision structure this way. Suppose that you have a decision to make, like whether you're going to come to this lecture or whether you're going to sit in the green lounge. And suppose for decisions like that, you use 3 variables represented up here by A, B, and C. Say one of those considerations is entertainment value. And if you decided to come here based on entertainment value, you made a mistake. but just to run out the analysis, okay, a second consideration might be educational value. Now, so far, maybe not a lot of educational content, but you're probably still hopeful enough to stay. And then maybe a third consideration is reputational consequences. That is, what will your fellow students think of you if you show up here rather than in the green lounge? Now, putting those 3 variables together, you can come to a decision, choice 1A or choice 1B, either coming to this lecture or staying in the green lounge. Now, that's a different kind of decision structure than the one I'm interested in. You could still have A, B, and C considerations, 3 variable considerations, educational value, entertainment value, and reputation effects. But the idea of the lexically ordered decision structure is, suppose that those 3 variables left you in equipoise. You just weren't sure what to do. Lecture, green lounge, I don't know, I'm turning my hair out. These 3 variables, they don't all point in the same direction, and I'm trying to balance them out. Now, one possibility is you just sit in stalemate, maybe for years, and that would be a bad outcome, very bad outcome. So you might decide, well, if and only if those 3 variables are in equipoise, then I will bring some other consideration into play in order to break the tie between choice 1A and choice 1B. So that's what I'm interested in. Now, there's an intermediate decision structure I thought I'd point out just to distinguish it. Here we've got, this is lexically ordered decision structure. That is, A, B, and C decides on whether you take choice 1 or choice B. Then, if choice B is selected, D, E, and F, 3 other variables come in to decide choice number 2, whether to go to choice 2A or choice 2B. Here we do have lexical ordering, but we don't have the same decision. Choice 1A and choice 1B are defined as different choices, different decisions from choice 2A and choice 2B. So a concrete example would be bifurcated trials. Think about a bifurcated capital trial, where there's a guilt phase and a penalty phase. So one stage is to decide whether beyond a reasonable doubt the defendant is guilty. The other stage is to decide if the defendant is guilty beyond a reasonable doubt. What should the penalty be? For example, death or life imprisonment. Now, I don't think anyone would sensibly say that the penalty phase is a tiebreaker for the guilt phase. We would conceptualize them as different decisions, one about guilt and one about penalty. Now, it's true that you never get to the guilt phase unless and until there's a penalty phase, unless and until there's a guilt determination. So there is lexical ordering of the rules. But we think of those as separate decisions. I'm interested in tiebreaking decision structures narrowly defined as lexically ordered decision rules designed to give the same decision. And then as a component of that consideration, what kind of variable would you put in the tiebreaker stage? Now I want to admit up front that this is a little strange, this structure. It's not one that is typical for most decision makers in most situations. It appears in life and law, it appears in soccer, it appears in the United States Senate. But it's not a pervasive decision structure. In fact, it's a little odd. And what I want to try to explain is how it's odd, what makes it strange, and what makes the structure nevertheless sometimes useful, and even illuminating about not just bits and pieces of law, but law as a whole. Okay. So strange. How would you justify a structure like this? You can start off by puzzling this. Well, suppose you put a variable relevant to the merits down here, like variable D, cheap food. Now, suppose you put that in the tiebreaker situation, you're thinking about putting it in the tiebreaker stage. Why wouldn't you throw it up here with A, B, and C? Why would you wait to consider cheap food only on the occasion that educational value, entertainment value, reputational value all cancel out? That doesn't seem to make sense. So if there's a relevant variable, well, keep it up here with A, B, and C. And if a potential consideration is simply not relevant to you, why put it in the decision structure at all? So we need some motivation for this odd, awkward, weird type of decision structure. So how might we be able to justify tie-breaking decision structures? Well, I'll give you at least 4 possibilities, and then I'll focus on the last one. Here's 4 possibilities. The first one is that perhaps some variable is so morally and categorically inferior on the merits to the others that no matter which direction that variable points, it could never overcome even the slightest nudging in a different direction from the other variables. Cheap food is so unimportant to you, it just doesn't matter compared to education, entertainment, and reputation. Only when you're in equipoise on those would you ever consider cheap food. Now that to me just seems implausible across a wide, not just this situation, I'm not dumping on you, but across a wide range of situations. It really is an extraordinary statement. It means no matter how mildly these first 3 variables point one direction or another, and no matter how strongly this 4th variable might point, you never consider that 4th variable along with the others. Now, it's possible to reach these conclusions. For example, John Rawls in his theory of justice actually has lexical ordering for the priorities in terms of judging the justice of political systems. Like some basic liberties, like freedom of thought, must be guaranteed first. And only when those are adequately guaranteed do other considerations come into play. So it's possible, and it does happen every once in a while. But I just want to indicate that it's a challenge to come up with a moral theory that is that categorical. Usually better to just mix the considerations. Okay? So another possibility is political compromise, not high moral principle, but just political compromise. That might yield a tie-breaking decision structure. Moreover, it might yield some compromise on how often a, quote, tie is going to come about. The number of ties you have is a function of the situations you face and the lexically superior decision rule. If you engineer that lexically superior decision rule in certain ways, you'll increase the likelihood of getting a tie, thereby making the tiebreaker more significant. So as an example of this kind of compromise leading to a tie-breaking decision structure, think about presidential elections. So in the first generation of the new Constitution, the consensus, not the consensus, the compromise was forged such that the House of Representatives, voting by state delegations, would break the so-called tie when no candidate for president received a majority of the electoral votes. Now, the expectation was that would happen quite often, that candidates would have regional constituencies, multiple candidates would be running, and no one would achieve a majority vote in the Electoral College, thereby regularly throwing the decision into the House of Representatives. The House of Representatives constitutes a tiebreaker for this situation, and it's the result of political compromise. The vice president's tie-breaking role might be explained in the same way. Another possible way to justify tie-breaking decision structures is when you've got a problem of system overload. That is, there are so many options facing the decision maker that the whole system might break down, unless there's some fast and cheap screening device to take a first cut at the problem and make the decision more manageable. So, for example, in the city of Minneapolis at one point, they were flooded with thousands of applications for firefighter positions. And they didn't have the resources to evaluate all of these applications on the merits. So what they did is they randomly selected a subsample of all those applications and then engaged in the serious merits inquiry. Now that is a lexically ordered decision rule. Unless you pass the randomization stage, none of your application will be considered on the merits. So, and that's also about the same decision. Both the lexically superior and lexically inferior decision rule are about hiring firefighters. So that does count and qualify, but it's not the focus of my consideration here. I do think those situations are quite interesting, but they have a different feature from what I'm mainly interested in, which is situations where ties are considered intolerable. The system overload situation, there the tiebreaker is running all the time. The problem is the system is burdened at the front end. We need to screen out some possibilities before bringing to bear better judgment on the remainder. That is important and interesting, but there the tiebreaker is itself the normative main event, so to speak. I'm more interested in situations for present purposes where the tie itself is a problem, that a tie at that first stage is somehow catastrophic or problematic enough to prompt someone to design a lexically inferior decision rule using some consideration that never was entered the first stage of decision making. That's what I'm interested in. So if we think about intolerable ties, what might be the response? So suppose the concern is that a certain decision procedure is going to resolve most cases, but not all. There's going to be some remainder. And someone says, that's a big problem. It will leave some choices ranked equally. All right, well, the first response would be to question whether the tie is in fact intolerable. Are ties always intolerable? That can't be right. That just can't be right. So if you think about law, for example, huge chunks of law effectively mandate ties. So a part of equal protection law, for example, and a part of voting rights law, is to try to roughly equalize voting power within districts electing representatives. The command there is that people be more or less tied. Moreover, it's okay to have preferences that are basically equal, apples and oranges. You might like roundish sweet fruit and not want to make a distinction between the two. U.S. News and World Report, when it ranks schools, hey, it's really hell-bent on giving, using one value, some numeric metric, ranking schools. You know what? It tolerates ties. Sometimes schools come up tied. Does the world end? No, the world doesn't end. That's not a problem. So having a tie is a form of equality that you might actually want. Sometimes as well, the response should not be ranking, but something like sharing or increasing the benefit to be distributed, and so on. So the first thing you want to ask yourself carefully is a tie really so bad? Now, sometimes it will be. When the question is, who is the President of the United States? Or the question is, who is my doctor? It's usually better to have one and only one of those things at the same time to avoid conflicts and so on. So sometimes ties really will be problematic. All right, so suppose we've got a good enough reason to think that ties need to be avoided. Well, we don't have to have a tiebreaking decision structure to get at that problem. We can prevent ties in more than one way. So here's one way. One way is by raising bars, loading the dice one way or another within a unitary decision structure. So think about civil litigation, for example. Now, people know that as far as human perception can achieve, some cases will seem equally weighted on the evidence. And at the same time, judiciaries are committed to resolving disputes. That is, they don't say, in fact, I don't think ever in their history have they said, I don't know, I'm stymied, I can't do anything. They always, to the extent they even suggest they don't know, which is rare, they say, I don't know, and look, a rule is rushing in now to resolve this dispute. So in fact, they do know. They just don't know on some first cut, then they have a tiebreaker to resolve the remainder. Well, again, without getting into a tiebreaking decision structure, you might say, well, we foresee that the evidence might be equally balanced in civil litigation. We don't want ties for one reason or another within the judiciary. And so we will simply raise the bar for one side or the other. That is, we could say, for the defendant to prevail, the defendant must be more persuasive. Or we could say, for the plaintiff to prevail, plaintiff must be more persuasive. Now, if the evidence is in equipoise, we've got a decision rule that will resolve that case, and not just that case, but every case. Okay. Similarly, with the majority vote requirement, you've got to choose which way you want to load the dice, toward the status quo, or toward the proposing party, or in some other direction. But you can load the dice, raise the bar in one direction or another, and resolve maybe all tie situations. Now, you can't resolve all ties, actually, with this strategy. In certain situations where the competition is based on simple numerical metrics, like how many votes. Most situations, raising a bar is going to resolve basically all the ties. But in a more subjective setting, like is the evidence more persuasive on one side or the other, there will be debates about whether, even if you raise the bar to plaintiff must be more persuasive, well, has plaintiff really been more persuasive? A little bit, maybe it's an equal, there's still going to be uncertainty. And so it won't fairly resolve all of those situations by simply raising bars. Moreover, there are other arguments for decision strategies that will push you away from raising bars. There are other possibilities, though, for preventing ties without a tie-breaking decision structure. Think about this possibility: adding more variables, or adding more gradations within variables. So take the baseball situation with the runner charging towards first base. Suppose we got excellent video technology and we started using replays. That would probably improve over the perceptions of umpires using their vision watching live action. So you could use technology to get better judgments about the metric in question. And that will effectively reduce ties as well. But those strategies will only go so far. At a certain point, you're going to run out of relevant variables. At a certain point, it's going to be too costly or impossible to improve your perception of who's got more than someone else, who was faster than someone else, who was better than somebody else. And so then you turn to tie breaking. All right, so suppose you've got an intolerable tie and the prevention strategies have too many costs to be deployed. How do you break ties? What are the possibilities? All right, well, go through three possibilities and then we can compare them. All right, one possibility is going to be to use a relevant variable, some variable that is avowedly relevant to the outcome, to the merits of the outcome. Another possibility is to use a random variable, a lottery of some kind, to use randomization. And a third possibility is to double count a relevant variable in the tie-breaking decision stage. Okay, so to illustrate these possibilities, suppose you've, again, got three variables you believe are relevant to a decision. Using only two variables to make the decision is likely to produce more ties, more situations of equipoise, than adding a third variable. So if you think variable C is relevant, throw it into the mix, and adding this variable does tend to reduce the probability of a tie. Does tend to, not all the time, but most of the time it's going to reduce the probability of a tie. Okay, so that's a possibility. But placing the same variable here in the tie-breaking decision location, the lexically inferior decision rule, tends to reduce ties even faster. So if you have three considerations, say entertainment, education, and reputation, if you really do fear a tie, that you're going to end up in stalemate, immobility, equipoise, loggerheads, whatnot, you may throw that third variable into the tie-breaking decision stage, and you will reduce ties even faster. So just to show you some computations, which Dan Roberts helped me with. So here are ties with 5 value variables. That is, variables that could take any of these 5 values: -2, -1, 0, +1, and +2. These variables, these values represent the following. 0 means that the variable is itself in equipoise. Like entertainment value, you might think, well, going to this lecture, not likely to be very entertaining. Going to the Green Lounge, not likely to be very entertaining. So 0, you can look at the tie on that variable, an equipoise on that value. On the other hand, the variable could point strongly in one direction or only weakly in one direction. So -2 is pointing strong in one direction, +2 is pointing strong in the other direction. So if we've got 5 value variables like this, and we can either have no tiebreaker, that is, we just throw those variables into the mix. I think that's the ordinary way of making decisions. Come up with all the relevant variables and throw them together. We will reduce ties. Adding another variable will reduce ties. But if we throw that last variable into the tie-breaking position, we'll reduce ties more effectively. So if you go from one 5-value variable and assume that there's an equal chance of any of these values coming up, then there's a 20% chance of a tie with that one variable. It turns out if you add a second 5-value variable, there are then 25 permutations, and once again, you get a 20% chance of a tie if you work out all the permutations. That is, 20% of the time, one of the variables is -2 and the other is +2. One of the variables is -1, the other variable is +1, or both variables are 0. Okay? But if instead you take that second variable, a 5-value variable, and put it in a lexically inferior decision rule, now the chance of a tie is 4%. That is, the first 5-value variable left you with a 20% chance of a tie. Then and only then you turn to that second variable, and 4 out of 5 times it will resolve the problem for you. So only a 4% chance. As we add more and more variables, it's true, just keeping a unitary decision structure reduces ties all the way down to 10.4% with 7 variables. How many 7-variable decisions are there? That's pretty complicated. In any event, if you always reserve one of them for the tie-breaking situation, you can get ties down to a 2.2% chance. Moreover, if you can find a tiebreaker that always points in one direction or another, like, for example, defendant prevails, defendants are easy to identify, then the chance of a tie, if that variable is left in the tie-breaking decision location, the chance of a tie will be 0. You will eliminate all ties. But throwing that unidirectional variable into the mix will not suppress all ties. So it is true, just making your decision procedure more complex, adding more relevant variables, that itself will reduce ties. But you will likely kill off ties more quickly by throwing that variable, an additional variable, into the lexically inferior position. Okay, so same variable here tends to reduce ties faster, but then there's the cost. And the cost is, when doing so, you increase errors of various kinds. Now, depending on the complexion of these variables, the problem could be severe. That is, by ignoring this relevant variable, only if and until the other variables cancel out, you might actually end up with the wrong decision. You might end up with those first relevant variables pointing in one direction, but only softly. And had you only considered that third other relevant variable, or fourth other relevant variable, you would have flipped directions entirely. Now, that'll happen in some percentage of cases. Won't be a high percent, but it depends on the characters of the variables. Moreover, you will also miss ties. That is, that additional relevant variable, which you've demoted down to the tie-breaking decision stage, might itself have put all the other relevant variables into equipoise, if only you could have considered it from the start. So this decision structure, in a way, artificially suppresses ties. Now, in one way, that's good, because if you're very frightened of ties, you want them suppressed. But it's nonetheless a cost. It shields from your view situations in which the decision really is in equipoise. Deal with it. These rules obscure that fact. And another effect is, in many, many situations, it will lead to erroneous estimates of the magnitude effects. That is, how strongly you should feel that you ought to go to this lecture rather than go to the Green Lounge. If you throw out relevant information and you say, I'm only going to consider it when all the other variables are in equipoise, only then you are likely to get some missed reversals. You should have gone in the other direction. You are likely to get some missed ties every once in a while, and often the magnitude or your confidence in one direction or another should have been different. It should have been even stronger, or it should have been weaker. So that's the trade-off. So we can call this a relevant tiebreaker, a relevant variable tiebreaker. The upside is it reduces ties faster than putting this third variable up here in this mixture. But the downside is it increases a variety of errors. Okay, what about, suppose that you think that those errors that you're going to encounter are just too problematic. And so you want to keep relevance variable C together in the mix with A and B. What's another option? Well, another option is to use a random tiebreaker. This is my representation of randomization. I couldn't figure out how to do it. But maybe dice would have been better. But you could throw a random variable in there, a lottery. Now, here's an interesting thing about throwing a random variable in. It also reduces ties quickly. But more than that, it increases no errors. No errors. Unless you're in the awkward situation of believing that a random variable should have been thrown in with the other variables at the beginning. Well, when is that ever going to happen? When are you ever going to say, you know what, when we take a vote in the U.S. House, we count the votes and then we throw in a random vote? People don't think that that's helpful. They think a random variable is irrelevant to the merits. So that means you're never losing information at the first stage. You're using something intentionally irrelevant. Say, for example, giving equal opportunity for any of the outcomes. Now, if you need to make a choice, and a tie is terrible, randomization will not only avoid any errors, it will decisively resolve every situation. So here's an example. More than one, but there are more than one, even in law, but here's an example. In candidate elections, at least in small jurisdictions, every once in a while there's a tie vote, 457 to 457. Now, what do you do then? What do you do then? Well, one possibility is raise the bar for who? Raise the bar for the incumbent or the challenger? That's really a highly contestable choice. Here's another possibility. Well, we'll just have a runoff election. That's costly, and you get a different turnout in the runoff as well. And so several jurisdictions say, we play a game of chance. We randomize. That solves all the election ties, and they're very rare. It's very cheap, totally decisive, and you don't think we're missing something by not having randomization at the first stage. So that's another possibility. But the downside is it's politically implausible in some of these circumstances. Think about courts and judges, for example. Suppose a judge said, I've worked very hard on your case. It's a challenging one, I have to say. And bringing to bear all my experience and learning, the time and effort I put in, I don't know. I'm not sure. But you know what? We're in the dispute resolution business here, and so we're flipping coins. Now, it turns out you'll lose your job as a judge if you do this. This happens every decade or so at some state trial court. Somebody flips a coin on the merits, and they get ousted. It's one of the most serious breaches of professional discipline. Now, theoretically, there's a reason to use randomization even on the merits of adjudication. Moreover, we're randomizing the assignment of judges to the cases, so it's not as if randomization is foreign to adjudication. But there's at least a political and a practical problem to using it on the merits. So suppose you don't want to waste a relevant variable in a tie-breaking situation, in the tie-breaking decision rule. And suppose also randomization is off the table for one reason or another. There is another possibility, and that is to double count. And double counting looks like this. A, B, and C stay in the first stage, but then C repeats in the lexically inferior decision location. Now, here's a great thing about adding C. You don't miss anything at stage one. You've got all the relevant considerations. So it does not increase errors, at least not without some more complicated story. The errors do not increase by double counting with C. That seems terrific. Moreover, by using a relevant variable to break ties, you might avoid some of the political problems with randomization. Because you can say, look, we considered A, B, and C, then we ran into a tie, and then we used a relevant variable. Don't you understand? Cheap food is relevant. We should use that in a decision. That's not such a problem, is it? Hell, we could have drawn lots or something. You would have gone nuts. We'll use a relevant variable, okay, but we'll double count it. There is a downside, though. And the downside is about incentive effects. Because by double counting C when there is a tie, and if there's a foreseeably substantial number of ties on the horizon, people may well adjust their behaviors in problematic ways because they see C appearing twice. That is, it's both in the mix, and if there's a tie, it will be decisive. Now people will start trying to show that they've got so much C. You can't believe it. I've got all the C. I'm so C-worthy. That can be problematic because you've now overweighted the variable. And if you try to relax its weight at the first stage of the decision, when it's A, B, and C up here, if you try to just reduce the weight of C up here to compensate for the fact that C will break all ties, well, now in situations where you never get to the tie-breaking decision stage, you are going to run into errors again. So it might be the best you could do it in an imperfect world. So it is a possibility. You can't have randomization, and you can't tolerate putting C only in the lexically inferior position. Okay, reduces ties without error, but it creates an incentives problem. Well, now let's try applying some of these conceptual and normative lessons to three more concrete and specific situations. So I'll say a few words about each and a few more words about the third, about law and adjudication in general. Okay, so a few words first about affirmative action. So think about affirmative action programs of one kind or another. Could be affirmative action based on race, or sex, or income, or legacy status, whatever you want to think about. And suppose it's in the situation of school admissions. These affirmative action programs can be structured as tiebreakers or not. So, for example, in the famous Grutter decision, where the U.S. Supreme Court tolerated a certain kind of race-based affirmative action in higher education, that decision structure that the court was, in a sense, recommending and ratifying was not a tie-breaking decision structure. The idea was throw race in with a bunch of other variables, a bunch of other relevant variables, consider them all together and individualize. Then consider another Supreme Court case, parents involved. That had to do with student assignment systems, for example, in Seattle. In that situation, the way students were assigned was, well, first, you think, for oversubscribed schools, keep siblings together. That is a lexically superior rule. If you had a sibling in a particular high school, you were entitled to get into that high school, even though oversubscribed. Nothing else could trump that. If, however, you didn't have a sibling, then racial balancing was considered. So the school system had set up racial boundaries in a way. That is, too many of one race concentration would be problematic. So then consider how would the race demographics of the schools change by adding this person rather than another to an oversubscribed high school. And then at a third stage, if that didn't resolve the problem, then think about geographic proximity. That's actually a lexically inferior rule of a third dimension. And then fourth, if none of that supplies an answer, then randomize, then use a lottery. Okay, now in that situation, the US Supreme Court said, well, we don't like this. We're holding this unconstitutional, the school assignment system. Now, interestingly, in part of Chief Justice Roberts' opinion, he says, well, in this tie-breaking structure, he doesn't call it that, but that's what it is, it's true that race doesn't always play a role, but when it plays a role, it can be decisive. Now, that's missing the point of tie-breaking decision structures. To understand whether this variable means a lot or not, you can't just focus on what it does when there's a tie. You want to think about how often there will be ties. Okay. So one problem is, for those who have concerns about these affirmative action programs, it seems that they've really got it out for tie-breaking decision structures. But they're not quite understanding the substantial differences between a tie-breaking decision structure, where race might come up seldom, but then be decisive, and a big mix of a bunch of variables, including race, where race might habitually be important in evaluating applications. But there's also a problem here, now we should recognize, for those who want a factor like race or sex or income or legacy status to be included as a tiebreaker. Well, if you do that, and if you concede that that variable is relevant to the merits of the decision, who ought to be in this school, if you demote that variable to the tie-breaking status, you're going to increase your error rate. That was the lesson from the discussion we just had. If you think it's relevant, but not so weakly relevant that it's categorically inferior to every other consideration, you will increase your error rate at the first stage. So I'm not sure how many affirmative action proponents take the position that, for example, race or sex is relevant to building a law school or a college or whatnot that works well, but think it's so unimportant that no amount of gain toward critical mass can overcome the other variables that are in consideration. That's a hard position to take. All right, so now we can drop down to interpretive method. Turns out that many interpretive methods or components of interpretive methods are described in a tie-breaking form. That is, certain considerations are supposedly never to be considered unless and until the other considerations wash out. Sometimes this is said by some judges about legislative history, for example. Here's another concrete example. The rule of lenity. Now, you might have come across this before. So if you've got an ambiguous statute, then in effect the tie goes to the defendant. Interpret the criminal statute narrowly so that the defendant is not criminally punished. Okay, and this rule also is described in a tie-breaking fashion. That is, in its most recent version, the instruction is, use all your canons, your ordinary canons of statutory interpretation. If and only if you're left with ambiguity, then drop down and use the rule of lenity. But now the same critique can be lodged at the rule of lenity as some tie-breaking structured affirmative action programs. If you think lenity is a relevant consideration in shaping the criminal law, then why not keep it together with the other variables? It will reduce your error rate. Now, one problem, of course, is that every once in a while, a judge really should end up in equipoise. They will consider lenity with all the other tools of statutory interpretation, and they will once again yield the honest conclusion, I don't know. But they can't say I don't know. That's not permitted to them. They're an institution designed to say I know in one way or another. They have to have a tiebreaker. And one thing about the rule of lenity is it's very easy to use. If you've got ambiguity in a statute, you are not going to have ambiguity in who is the criminal defendant. That will be easy to identify. On the other hand, it could have been a rule of severity. That is, if in doubt, using the other standard, the other tools for statutory interpretation, read the criminal law more broadly. Could have been that, and it could have resolved ties just as effectively. So again, people are in the awkward position with the rule of lenity. Those who want it as a lexically inferior decision rule, they must be in the position something like it's relevant, but so barely, ridiculously, lowly relevant that every other consideration trumps, no matter how weak. That's possible, but it seems to me implausible. More likely is they're just finding a convenient way to resolve all disputes of statutory interpretation in criminal cases, and moreover, they're doing it in a way that has a little bit of a preference for private ordering, a little bit of a libertarian preference built into it. Now, there's another account of the rule of lenity and other statutory interpretation canons that are phrased as tiebreakers. One possibility is judges are not actually using them as tiebreakers. They're just saying that. They don't really understand the difference between a unitary decision structure and a tie-breaking decision structure. Now that sounds bad. That sounds like a criticism. But it might end up being good for the rest of us that they don't understand. So suppose they are in fact taking into account lenity the whole time. Well, terrific. Now a relevant variable has been mixed together with the others, and there's no problem of defending lexical superiority and lexical inferiority. That could be good. Another possibility, too, is that subconsciously or consciously, they are double counting. That is, they know that things like the rule of lenity are supposed to be taken into account at some point. And they, in fact, do take it into account in trying to understand the scope of the statute. And then, at the end of the day, if they're still unclear, they re-invoke the rule of lenity. Now, this creates some incentive problems, some other criticisms. But it seems to me better than isolating a variable that you think is relevant and into a place where it's never going to be considered unless there's equipoise. So one possibility is they're surreptitiously double counting, and in a way that's the best outcome that a court can achieve. After all, if the court said, I'm not sure about the ambit of this criminal statute, I'm now flipping a coin, that judge would be out of the job. Okay, so one last possibility is that law and adjudication writ large are just two big tiebreakers. So while I admit that within law, finding these lexically ordered decision rules is difficult, they only occur in patches of law. It might be that all of law, or at least all of adjudication, is aptly analogized to a tie-breaking decision structure. So think of it this way. For how many of you would it be your first inclination when you understand you're in a dispute to go to a court, or a city council member, or a governor? I think the number is round about 0. Almost nobody thinks that way. There are some people who have mental illness problems, who are frequent filers, they call them, and maybe that is their first thought every time a dispute comes. But even for them, that seems unlikely. For most people, your first thought is not to litigate or to organize politically in solving your disputes. That's not your first thought. And behavior matches these reported preferences. People, in fact, do not turn first to lawyers or politicians to resolve their grievances. Often, they just lump it, so to speak. They just take it. They don't complain to anybody. Every once in a while, they complain to the person who they believe is wronging them. And every once in a while, within that subset of situations, they talk to a lawyer. And every once in a while, a claim is filed. And every once in a while, there's actually litigation. And every once in a while, there's actually a trial. And every once in a while, there's an appeal. But wow, that's really a rare situation. So both in terms of reported preferences and practices, using law and litigation, that's not the lexically prior option. Moreover, courts themselves in particular have designed themselves so that they will be, in effect, tiebreakers. Not only do they accept most settlements as a trump on their ability to order affairs, they affirmatively encourage settlements. They do it in multiple ways. For example, requiring you to go to a bunch of meetings until you just can't take it anymore. So you're just going to settle. That's one way. The rise of alternative dispute resolution is a feature. So is the set of exhaustion rules that the courts use, not just federal courts, but state courts. So much adjudication nowadays takes place in administrative agencies. Within those agencies, those cases could have been in a court, but they're not. Through exhaustion rules, parties ordinarily have to fight their way all the way through an administrative process before they ever see a court. And moreover, federal courts in particular are last word freaks. That is, they want to order their decision so that if they ever speak, it's supposed to be the, quote, last word on the subject. If somebody else is going to review their conclusion on a particular issue, that is a reason for them not to adjudicate at all. They will say it's non-justiciable if the president gets to review my decision on X or Y. So courts have organized themselves into a position matched by the preferences and practices of ordinary people, such that that institution, maybe law in general, but more specifically courts, are designed to be tiebreakers for the rest of social life, for those disputes that can't be resolved somewhere else. Now, what should we think about that? There is some analogy. It's not perfect, but some analogy. So how do we want to evaluate law and maybe just adjudication as a tiebreaker? Well, here's one possibility. Hope that they are acting arbitrarily. Hope for arbitrariness. Why? Because that would be a random variable for resolving intractable disputes that find their way into a court system. Counterintuitive? Yes, it is. But it means that every time you read a case and think, this is just kook, it's crazy, it's senseless, I don't understand, you should have a second thought. That would be a good tiebreaker. They don't know what they're talking about. It's like a random variable. It's like a roll of the dice. Moreover, the system is now riven with randomization because the judge and the jury assigned to your case, especially the judge, is driven by a lottery that usually takes place backstage. And because judges differ in competence and in ideology, especially in tough cases, which after all are the kind that are ordinarily litigated, that random decision selection process, who's going to judge your case, is going to have outcome effects. Some people think, horrible, we've just run into tension or conflict with this professional responsibility rule, which is courts should never be flipping coins on the merits. And another response is, maybe that's pretty good. Randomized decision making for these very tough disputes. Now, nobody's going to be very comfortable with that. So another possibility is to think of courts in this fashion. Maybe instead of adding some other relevant variable, like their ability to engage in rational judgment, in moral reasoning, maybe what's happened is they've roughly reflected the norms existing in the rest of society. And so courts are, in a sense, double counting those norms. More or less, there's a mainstream constraint on the results judges produce. Judges are not aliens to the rest of the culture. They are not selected from some other country. If you're a member of Acorn or the Tea Party, it's very hard to become a judge. So whether elected or appointed, judges are a professionalized subset of the mainstream. Those judges do differ, and which judge you get, which decision maker you get, is partly a function of randomization. So by both reflecting and randomizing, the courts find ways to decisively resolve every dispute that they face. They also add some rationality. They do, and some moral reasoning. But when you take a step back and think about courts, it seems that they have pushed themselves further and further into a lexically inferior position. People have responded in kind, and when we take a step back and try to think what kind of tiebreaker the judicial system is, we might say that it's rational, yet random, and reflective at the same time. The tiebreaker, imperfect, but so are nearly all tiebreakers. They are often decision strategies for imperfect worlds, and courts are of a piece. All right, well, I'll be happy to take some questions. Yes?
Yeah, so you mentioned at the end majority preferences having this double counting role.
Yes.
But that relative to decisions outside of the legal system,
Yes.
courts are playing a randomization, tiebreaker role.
Yes.
Okay, I wonder if it might make sense to say that courts are playing themselves a double counting role.
Yes.
In those outside decisions, because outside decisions are made in the shadow of the law.
Yeah.
But the decisions that courts are going to make also play a role outside of courts as one of the factors that enter into the decision.
That's right. So you're quite right about this. So a couple of points to make about that. One is that the analogy is, I think, apt but imperfect, and this is one of the ways in which it is imperfect. There are spillover effects by this, even if it seems close or lexically inferior decision process, there are spillover effects. People take into account what judges said. So a couple of additional responses. One is, it seems that few people take into account what judges say on normative questions, especially normative questions important to them. There are a series of studies, it's not a big series, but where investigators will ask people, okay, well, what's your position on issue X? What if I told you the Supreme Court said this on issue X? Well, sometimes people move a little bit, and they say, oh yeah, all right, maybe I'll change my mind. Often they just do not. Moreover, people have to know about, they have to be aware of those judicial decisions for them to for those decisions to affect judgment outside the courts. And then finally, the fact that there might be an effect on people's feelings or judgments outside the courts because people are operating in the shadow of the law doesn't actually eliminate the tie-breaking decision structure. So think about the penalty shootout in soccer. There are some teams who think, you know what, we're really just not as good as that other team under the ordinary rules of the game. We get tired, we're not as accurate, we're just not going to score as many goals. But you know what we should do is if we're ever tied, or even at 0-0, just delay like mad until we get to that shootout. Why? Because some people think the shootout is basically random. That is, if the goalie guesses the right way, save. If the goalie guesses the wrong way, goal. And then it just seems like flipping coins. So in that situation, even though we have a clear tie-breaking decision structure, and it's true that people are adjusting their behavior to try to get into that decision structure, we still got one. It's just that the two stages aren't totally sealed off from each other. But again, I just want to acknowledge what I said at the beginning, which is I think it's an apt analogy, but an imperfect analogy. And one of those reasons is that some people pay some attention to what courts say on normative matters, so they organize themselves partly on judges' preferences. I should say there's a small community within legal academia who think, it seems to me more or less, that life ought to be a tiebreaker for law. That is, law should be taking the forefront in reasoning about moral questions, maybe through legislatures, but also maybe through courts. And that is the optimal location to have difficult moral disagreement, in that location, in that forum. I think that's a much worse picture of how courts are actually operating. So I think my analogy is better, but I want to acknowledge that some people think that if I'm right, that's terrible. Yes?
How, if at all, should a choice of tiebreaker be influenced by whether the decision maker internalizes the costs or benefits of the tie?
Yeah, well, whether they internalize costs is always an issue. It's always a problem because you get a couple of different effects. If they don't internalize costs or benefits, you could say that they're independent. So now they're bringing to bear their independent judgment. But they also might seem so detached from the consequences for other people that they won't be sensitive to those outcomes. With the judiciary, people seem to want to wall them off a little bit. With ordinary politicians, they don't want them walled off. They want them to feel some of the consequences. So I just say that it's a general phenomenon in designing decision protocols, and it's not really different with tie-breaking decision structures. I should say, though, that tie-breaking decision structures, because they're a little bit more complicated, some consideration is going to come into play if and only if others wash out, that it can create an additional dimension for strategic behavior. So that is something special to this structure. But in terms of internalization, I think it's just a general question that we have for decision makers across the board. Yeah.
I wonder if you could comment on the implications of this sort of theory of the function of law plays in society on like the rule of law discussion that gets had about developing nations and developed economies. Because I mean, basically, if I'm trying to imagine ties outside the court, what you're saying is that all of these various forces are inequitable. Well, some of those forces might be, physical brutality, power, systems that we don't like. And so when we say rule of law, what I think we mean most of the time is that behavior outside the legal system is largely structured in a way that's consonant with rules that the legal structure itself would place on that behavior, which would seem in that case to make that tie-breaking function less and less effective, and actually mean that more and more disputes would go to courts.
Well, the last part, I'm not sure about the logic of it, so you have to explain a little bit more about it. But let me just say about rule of law, I don't think there is any one thing that we mean by it. One idea of rule of law is it's about efficacy. Like there are some legal norms of whatever kind, and you can judge them normatively. Well, we just want to know if they're efficacious, do they actually influence behavior. But it turns out that those legal norms are so often influenced by non-legal norms that it's very hard to pick up the efficacy. Is it because the system was already structured, society was already structured to prefer those norms, or is it because law actually instigated that norm? So we can definitely see some situations in which formal legal norms are departed from. That's true. And then we just say the legal system is breaking down or is not efficacious. But it wouldn't necessarily change the situation of courts or politics in general as the not preferred method of dispute resolution, the not preferred method. Now, I don't want to speak to every cultural situation. In the US, things have developed such that people's preferences and practices are to use politics and in particular courts more or less even though courts are always subject to revision in some way. Our system has developed that way. I can easily imagine other systems where I would rather have courts and politics as the lexically superior decision structure, and life to be the tiebreaker when we can't figure it out in those forms. In the US, we happen not to have that, and I don't think we'd really revert to the other model either. But I wouldn't be able to impose it on another situation where it turns out legal institutions really are our best hope for coming up with good legal norms. For the US, I think that's a harder case for me. Yeah, it's an excellent question. More questions? Talk to you into submission. Got a couple more minutes. I want you all to have time to go to your classes. I'm happy to talk more about this subject. Let me ask you this. When's the last time you think, has anyone recently used a tiebreaker to resolve some problem you had? The answer is no. I think the answer is no. Does it also seem intuitive to you or illogical to suggest that the legal system is composed of a bunch of decision rules that are not themselves tiebreakers, but that the institution as a whole is aptly characterized as a tiebreaker? Is that counterintuitive? Is that illogical? Or does that make sense to you? I feel like calling on something. Yeah, go ahead.
I think it's logical. It's like when parties come to an impasse, then they have a tiebreaker and it's legal system. So it seems right to me.
Yeah, it seems right to me too, but the fun thing is, when I investigate individual legal rules, I almost never find tiebreakers. That is, they're just either separate decisions with a bunch of other variables, or we've got a bunch of variables all thrown in. Interpretive method does seem like an exception, rule of lenity and so on, but you have to struggle a little bit. Now, in ordinary life, in the ordinary boring rules, there actually are quite a few tiebreakers for low-stakes decisions. Like, for example, yield right. When vehicles approach an intersection at about the same time, the rule is yield to the right. This is a super effective tiebreaker. And it's even better than randomization, because if people had to flip coin, you have to coordinate, you have to get out of your cars and stuff, that would be a waste of time. But this tiebreaker, for those who get to an intersection at about the same time, very effective, resolves all disputes, and nobody thinks that there's any moral content to yielding right rather than left. There's nothing to do with it. So you're not missing anything by not building into the rest of traffic law yield right. So that all sounds pretty good. That's one of these pedestrian rules. Tie would be really bad. Everybody would be sitting at the intersection. We don't really care that much which rule we choose. We just got to make sure that there is an outcome rather than a superior outcome. Okay. Well, thanks for listening. This is based on kind of an interminably long article that was published recently in the University of Chicago Law Review. That has some of the math and more of the details in it if you're interested. And I appreciate your patience. And while I don't think you probably got more entertainment than in the Green Lounge, I hope you got a little bit more education, and you definitely got the free food.